Based on this morning's docket. That is case number 104666, State of Kansas v. James R. Andrew.
Good morning. May it please the court. Meryl Carver-Almond on behalf of Mr. Andrew. And Chief Justice, if I could please have 3 minutes for rebuttal.
3 minutes is granted.
I think there are two non-mutually exclusive ways that we can get to reversal here. One is because the instructions just plain misstated the law. The second is because we don't give affirmative defense instructions regarding the victim. Either way, I think that this case is reversible because of this bad self-defense instruction that was given. Here, essentially, the district court gave a self-defense instruction that made it so that if the homeowner, who my client, looking at the facts in the light most favorable to him, did not know was the homeowner, if that homeowner lawfully was trying to get my client out of his house, then my client was not entitled to self-defense. But as we know, self-defense isn't dependent on what the victim is thinking. Self-defense is dependent on what the defendant is thinking. If my client...
From an objective standpoint, if the person was exercising lawful force in defense of dwelling, why isn't this self-defense not applicable?
Because the question is not whether the homeowner, will say in this case, just to keep it from being confusing, whether he was actually using unlawful force or lawful force. The question is whether my client objectively and subjectively believed that he was using lawful or unlawful force.
Correct. But why isn't that a jury question in terms of the subjective nature? But why wasn't it a correct statement of law to instruct the jury that if they found subjectively and objectively that the homeowner, the victim, had a right to defend the dwelling?
I don't think that the instructions were anything near like that clear. I'll start there. Because the instruction itself, the part that we're taking issue with anyway, when acting within this permitted use of force, self-defense is not available to the person being forced out. That doesn't clarify, and it's read in conjunction with the rest of instruction number 11, which talks about, and this is, again, the problems are intertangled here. Again, the problem with giving a self-defense instruction in regards to the victim of the case. Because
Can I clarify some facts?
Sure.
Is there any dispute that Mr. Garlick lived in the house and had the right to order defendant to leave?
I don't believe that there was, no.
Was there any question that Garlick told the defendant to leave before he pulled the knife?
I think Garlick definitely spoke for, even under the son Cole's version of the facts, I think Garlick said, "Why are you in my house? What are you doing in my house?" I don't know that there's necessarily evidence that he said, "Get out of my house." But I think somebody probably asking, "Why are you in my house?" could be construed as, "I don't want you here," maybe. So
if there's no question that defendant was in a place that he was not permitted to be, why are we even talking about anything? If you're a trespasser, you can't utilize self-defense or stand your ground or do anything like that. I mean, there's no question that defense isn't available, whether the other person's using force or not.
I think you've hit. No, sorry, did I cut you off there? Okay, I think you've hit on exactly what the question is, and that is was he lawfully in the house or not? And there was evidence, proffered evidence at least, the district court didn't allow some of it to be admitted, that he had the kind of relationship, and I think there's some evidence somewhere that this AJ was a cousin, where, he didn't knock on the door, he just kind of came in. And so, and hadn't been told to leave
And that's
before.
why you got the self-defense instruction at all.
Exactly.
So you got that. You're not arguing with that. You're just arguing with the jury being informed of the law applicable to the victim's position.
To the victims,
But how would the jury have understood whether or not to apply self-defense without understanding the law applicable to the victim's rights? How could the jury have possibly done its job on the self-defense instruction without the language that you're complaining about?
I think that it isn't necessary, and it confuses the issue because, again, it brings, and this is the problem with giving instructions regarding the victim, it brings the jury's
I
consideration.
don't think it's necessarily an instruction about the victim. It's just the applicable law. How would what else in those instructions would have let the jury know that self-defense is inapplicable when someone is trespassing?
The problem is the instructions focus the jury on it's an irrelevant consideration.
It's not. If he was a trespasser, he had no right to exert force. He didn't. I mean, that's the law, right?
That is
That
yes,
is law.
Yeah.
So what, if you could answer my question, which is, what else in the instructions informed the jury of that applicable law besides the language you're complaining of?
I don't know that anything did.
Okay. And didn't they need that in order to evaluate the merit of your client's defense of self-defense?
I think that that's where we're disagreeing, maybe. I don't think that they
How
did.
could they possibly have known whether to apply self-defense without that information?
I think maybe the problem is that there are better ways there would have been a better way to say it.
Is that your argument? Or is your argument that it should have been left out?
I think it should have been worded in a way that it wasn't mutually exclusive. I think
It is mutually exclusive. You just told me that's the law, that there's no right to self-defense if he's a trespasser.
there is no right to self-defense if he's a trespasser. But
Haven't
the
you just
jury had
agreed
the open question of whether he was a trespasser or not.
And that's a jury question. And
But they
that's the
didn't
question
get
they
that.
decided.
I'm sorry.
How did the instruction take that away from the jury? I'm not getting that. It told them the test to decide if the victim was using lawful force.
If the victim was using lawful force.
And if the jury applied that test and found that the victim didn't have the right to tell him to leave or to defend the dwelling, then they would have applied self-defense.
Maybe I can say this way. Assuming the victim is using lawful force, which, I mean, he's the homeowner, so he has certain rights there. He lives at the house anyway. There is a scenario under these facts where you could believe that even if the victim had the lawful right to force my client out of his house, the problem here really is that my client didn't know that the victim lived at the house even. I mean, he had no idea who he was. He could have just been some stranger that was there. The evidence showed there was a party going on, and he's at his family member's house and telling him to get out.
How did the instruction take that decision away from the jury, though? I'm not getting that. It told them, I mean, it gave them the objective and subjective test. The subjective part of the test was still there. It could have been argued to the jury that if they didn't believe that, then the right to self-defense was a valid defense.
The instruction told the jury, I'm going round and round in circles here, aren't I? The instruction told the jury that if Mitch, the homeowner, was lawfully using force, I guess, and maybe going back to the hypothetical that I used in my brief, sometimes both people actually are entitled to self-defense. And the fact in this case that really is the crux of the issue is whether my client knew that Mitch was a homeowner or not. I think, and maybe I answered Justice Byers' question incorrectly. I think if my client had known, and there was evidence that he had known that Mitch was the homeowner, lived there, had the right to force him out, then this would be a completely different case, and it would be a much worse case for me. But we don't know that. And if you look at some of the other cases cited in the brief in high school, in Jackson, in both of those cases, the defendant knew in high school that it was a law enforcement officer. In Jackson, knew, there was no evidence that he didn't know anyway, that it was a bouncer who you would presume has authority to kick you out of a bar. In this case, my client did not know, under the specific facts of this case, that this person had the right to force him out, which plays on his objective and subjective beliefs about what he was allowed to do. So under the particular facts of this case, as the homeowner, you do have an absolute right to throw out a trespasser. I can't disagree with that. But the problem is my client didn't know that Mitch was the homeowner, the home occupant, and therefore that plays into his objective and subjective beliefs about whether he was entitled to use self-defense. And that's what the jury was cut off. That is the factual scenario that the jury was cut off from taking note of.
So
with
if
the
I walk
instructions
into
given.
someone's house unannounced and there's a person there that tells me to get out, I don't have to get out if I don't know for a fact that they are an owner of the house?
I think that's a completely different fact scenario. If you walk into, if you and Justice Beyer have the type of relationship where you don't have, my grandmother's house, we used to do it when I was little. If you knocked on her door, you were a salesman or someone that she didn't want there. Everybody just walked in and you said hello. If you had that kind of relationship, and you just walked in and someone you didn't know was there, I walk into my grandmother's house like that, like I'm accustomed to do, and someone says, "What are you doing here?" My response would have been, "Well, what are you doing here?" That's more the kind of situation here. It's not the situation of someone walking into a stranger's house.
But the jury had all that in front of them.
They
The
did, but
jury
they-
had all of that information, and they were free to decide whether he was or was not a trespasser, really. I mean, that's what you wanted them to be able to decide. And what you're arguing here really is facts. He wasn't a trespasser. He would, as far as he knew, it was okay for him to be there. And the jury was able to evaluate that.
I don't know if he was a trespasser or not. I guess that's what I'm arguing, that the jury was not able to evaluate, that it should have
I
been a
don't
jury
understand.
question.
I guess I'll go back to Justice Lukert's question. I don't understand what about the language you were upset with prevented the jury from considering that question.
My argument is that the instruction made the self-defense claim mutually exclusive. Either the victim got it here or the defendant got it here. I don't think that that's true under the facts of this case. I think what mattered, what was relevant to the jury to decide, was my client's objective and subjective state of mind, and this was an irrelevant consideration that prevented them from fully considering that. That's my argument.
Okay, thanks.
Any further presentation?
I have nothing unless the court has questions.
Any more questions of counsel? Thank you.
Thanks.
May it please the court, the state appears by Stephen Obermeyer. This is not the defendant's hypothetical about going into his grandmother's house. This is a person who is extremely drunk, had been drinking all day. His house was torn up. The son's there. They have a confrontation that involves police. Son leaves and says, "I'm going over to AJ's or where the victim lives. Don't follow me." So the defendant comes over, bringing a 6 to 8 inch serrated kitchen knife with him, and walks in the house. And doesn't knock. We have a no-knock entry here. And then we have the various versions of what happened. And the trial judge, Judge Bennett, thought that there was conflicting evidence and that he needed to give the jury an accurate statement of what the law was in this scenario. And to just instruct the jury on self-defense that the defendant wanted, that he could go in there and claim self-defense, would not be an accurate, complete statement of the law. And Judge Bennett even likened the case to State versus High School, which was a case where a person's being arrested and wanted to claim self-defense. And the Court of Appeals said that if you do that, you can claim self-defense only if the officer is using excess force in making the arrest. And so that's kind of how this instruction came about, that the homeowner could use force in ejecting him, but if he used excess force, then the defendant could use self-defense. Did you have a question, Justice Johnson?
Did the instruction clarify that it's the homeowner if a person's being forced out of a dwelling by the homeowner? I can't remember how it was worded, because the argument is if you're being forced out of a house by someone who doesn't have the authority to consent or not consent to your being there, then wouldn't you have the right of self-defense? if someone without authority is trying to force you out of a place, and they have no right to tell you not to be there, you're not a trespasser, would you have the right to defend yourself? You understand what I'm saying? If you walked into some house where you think you have the right to go in, and a person that doesn't live there, doesn't have any authority over the dwelling, grabs you and is going to take you outside because they don't like your looks, do you have the right to defend yourself?
I think in that scenario, if you walk into somebody else's house, you have to assume somebody there telling you to get out
Has a right to be
authority,
there.
has a right to be there.
You
And
don't get to assume the opposite. And start
correct. And
battling
I,
them.
I don't keep an abstractive title by my front door in case that scenario arrives, and I don't think anybody should be expected to. But the jury was just given the language from the statute that a person is permitted to use force to the extent it appears to him, and he reasonably believes that such force is necessary to prevent another from unlawfully remaining in the dwelling.
No, I was talking about the court went one step further and said the person being forced out of the dwelling doesn't have the right of self-defense. Didn't the court go on and say that?
Yes, the last
And
sentence.
what was the language on
The
that?
language is, when acting within this permitted use of force, self-defense is not available to the person being forced out. And that's the language that's being,
In other words, the application of force by the forcer has to be lawful in order for self-defense to go away.
right.
And actually, looking at the instruction that was given in here, it wasn't the dwelling, it was his dwelling, which I think is important in terms of Justice Johnson's point. It is, the jury was informed that it had to be the forcer's dwelling. It uses his dwelling twice in the instruction.
Okay, it does say that, and there was evidence that Mitch Garlock lived there and resided there. But I thought the part complained of was that last sentence about when acting within this.
It is, but I think in the paragraph above, I think it clarifies that it has to, the person applying the force, it has to be their defense of their own dwelling.
I think it does, yes.
Do we have to overrule Alexander?
I think it's worth looking at the analysis in Alexander. And the dissenting judge felt that we have to follow Supreme Court precedent, which you want the Court of Appeals to be doing that. But the analysis in Alexander is basically one sentence at page 880. Because Young was not on trial, that was the victim, instruction number 14 should not have been given. It really doesn't explain why that we don't have to instruct the jury on the law when there's conflicting evidence. That's the only sentence out of Alexander that talks about it. And I would direct the court to the self-defense statute, which says a person is justified in the use of force against another, not a defendant is. Just because the PIC instructions, the one that the Alexander court is discussing, reads that a defendant is permitted to use self-defense, doesn't mean that isn't the law, that cannot be, that an instruction based on the statute 2132.12 can't be given to a jury when there's evidence to support it, because that statute applies to everyone. And so really there wasn't any analysis in Alexander. And it's kind of similar to the instruction about if you're an initial aggressor, you don't get self-defense, or if you provoke an offense. And I don't think I brought that up with me, but the pattern instructions, there's 3 or 4 of them that discuss that. And I think that Judge Bennett was trying to accurately state the law, given the different scenarios as far as what the jury found, and that as the majority stated, the instruction accurately stated the law. So I would ask that the court affirm the Court of Appeals opinion.
Any more questions? Thank you, counsel.
Thank you.
Reserve 3 minutes for rebuttal.
If the court has more questions, I'd be happy to answer them. Otherwise, I'll waive rebuttal.
Any further questions? Thank you, counsel. Thank you both for your arguments this morning. Clerk will take this matter under advisement.